Welcome to Philippine Constitution Unlocked. Explore how the Indigenous Peoples Rights Act recognizes Indigenous rights and native titles as an exception to the Regalian Doctrine, balancing ancestral domain protection, resource management, and cultural preservation. Regalian Doctrine and the Native Titles of Indigenous Peoples. What is the Regalian Doctrine? The Regalian Doctrine is a legal principle that says all lands, waters, and natural resources in a country are owned by the state unless proven otherwise. It is based on the idea that when a country was colonized, all land became the property of the government, and people needed to show legal proof to claim private ownership. This is a principle rooted in Spanish colonial law, which holds that all lands and natural resources are presumed to belong to the state unless proven otherwise. The constitutional basis for the Regalian Doctrine is found in Section 2, Article 12 of the 1987 Constitution, which states, "All lands of the public domain, waters, minerals, coal, petroleum, and other mineral oils, all forces of potential energy, fisheries, forests or timber, wildlife, flora and fauna, and other natural resources are owned by the state. With the exception of agricultural lands, all other natural resources shall not be alienated. The exploration, development, and utilization of natural resources shall be under the full control and supervision of the state. The state may directly undertake such activities, or it may enter into co-production, joint venture, or production-sharing agreements with Filipino citizens or corporations or associations at least 60% of whose capital is owned by such citizens. Such agreements may be for a period not exceeding 25 years, renewable for not more than 25 years, and under such terms and conditions as may be provided by law. In cases of water rights for irrigation, water supply, fisheries, or industrial uses other than the development of water power, beneficial use may be the measure and limit of the grant." What is a native title? Native title refers to pre-conquest rights to lands and domains which, as far back as memory reaches, have been held under a claim of private ownership by indigenous cultural communities and indigenous peoples, have never been public lands, and are thus indisputably presumed to have been held that way since before the Spanish conquest. Two legal concepts related to native title are ancestral domain and ancestral land. Ancestral domain refers to the vast territories traditionally occupied or used by indigenous cultural communities and indigenous peoples since time immemorial, including lands, forests, and resources essential for their cultural and economic welfare. These domains are communal property, inalienable, and cannot be sold or transferred, representing the collective identity of the community. Ancestral domains can be titled as a Certificate of Ancestral Domain Title, CADT, a formal legal document recognizing their ownership over these territories. Ancestral land pertains to specific parcels of land held by individuals, families, or clans within indigenous cultural communities and indigenous peoples since time immemorial, based on ancestral claims. Unlike ancestral domains, ancestral lands can be alienated under certain conditions, especially within the community. Transfers to non-indigenous cultural communities and indigenous peoples are restricted and may be subject to redemption rights. Ancestral lands can be titled as a Certificate of Ancestral Land Title, CALT, granting legal recognition of individual or familial ownership within the broader ancestral domain. These lands can be used for specific purposes, such as agriculture or residence. The idea of native title was first recognized in 1909 in the case of Carreño versus Insular Government. Mateo Carreño, an indigenous leader, won the case, proving that indigenous peoples owned lands they had lived on and used even before colonization, even without legal land titles. Despite this, the government mostly ignored native titles. The Regalian Doctrine, which says all lands belong to the state unless ownership is proven, made it harder for indigenous peoples to claim their lands. Many were displaced due to colonization, government projects, and development plans leading to loss of land, culture, and livelihoods, as well as poverty and inequality. In 1997, the government passed the Indigenous Peoples Rights Act to fix these historical injustices. One question that emerged was whether the Indigenous Peoples Rights Act violated the Regalian Doctrine as established in the Constitution. This was answered in the case of Cruz versus Secretary of the Department of Environment and Natural Resources, GR number 135385, December 6, 2000. Pursuant to the said decision, the law carves out an exception to the Regalian Doctrine by recognizing the native title of Indigenous peoples to their ancestral domains. Are there limitations to Indigenous peoples' rights to their ancestral domains? Yes. While the Indigenous Peoples Rights Act recognizes ancestral domains as private property, it sets some important limits on these rights. 1. Cannot be sold or transferred. Ancestral domains are private but belong to the whole Indigenous community. This means the land cannot be sold, transferred, or given to non-community members. This rule ensures the land stays with the community for future generations. 2. State owns natural resources. Even though Indigenous peoples can manage and use natural resources in their lands, the Indigenous Peoples Rights Act follows the Regalian Doctrine, which says that natural resources like minerals and forests belong to the state. Indigenous peoples can benefit from using these resources, but do not own them. 3rd, state controls large-scale activities. Indigenous communities have the right to use resources for activities like fishing, farming, or small-scale mining. However, large-scale activities such as mining or logging need state approval and agreements. Non-community members can only join these projects if the community gives their consent and the state agrees. Like, subscribe and share. Let's empower Filipinos one click at a time.